Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in our case number CV24-0286, Kaatz and Rainguard. Council, just remind you we are recording and live streaming the argument, so please identify yourselves and your client at the beginning of your arguments. Counsel for appellant, each side will have 20 minutes, but you're not obligated to use all that time. Appellant's counsel, if you'll watch the clock and reserve as much time as you desire for rebuttal. Also, please keep in mind we've read the briefs, we've studied the record, and we've discussed this case in conference. So, counsel for appellant, you may proceed.
We switched. Sorry. Apologies for that. May it please the court. My name is Brian Sanowski. I represent the appellant Rainguard Brands LLC in this case. The basic question presented to the court in this appeal is considering and applying the separability doctrine that applies to arbitration agreements. Does the arbitration agreement here related to the employment dispute that Mr. Kaatz has brought required to be arbitrated? The answer here is yes.
Counsel, I have a threshold question.
Absolutely.
Did you raise the separability doctrine in the Superior Court?
I believe there was a mention of that in some of our briefing, that it's a separate analysis, it's a separate document from consideration of the...
Do you believe you actually cited case law like you did in the briefing and referenced the doctrine of separability in the Superior Court?
I don't know if we cited the case law to the extent that we did it in our appellate briefing in the underlying
what
court.
would your argument be against us finding waiver on that issue?
That essentially federal law requires that the document, the arbitration agreement, be treated as a separate agreement. It's a mandatory portion of the Federal Arbitration Act under Prima Paint as well as Buckeye Cashing. It's a federal substantive law that applies to how the analysis is to be performed related to the case. My argument would be that it's not a waivable thing when it's part of the federal substantive law on the issue.
Let me ask
Absolutely.
another threshold question. Sure. Is the handbook a contract?
I believe that it provides contractual issues related to this case. The arbitration agreement would be a separate part of that. The document...
The handbook begins
sure.
That this handbook does not constitute an employment contract.
Correct. And it puts the employment contract in quotations. And the intent of that is shown by the rest of the document, because numerous times it talks in terms of this document does not alter the at-will nature of the employment relationship between the two parties. That's the intent of it being not an employment contract. But the policies and procedures set forth in there both apply to the employee as well as to Rainguard Brands. It sets forth the relation... I'm sorry.
Rainguard can change them at any time.
It can change the policies and procedures at any time if there's a need to do that. There's no argument...
If it chooses to do that.
Correct.
How is it a contract if one party can just change the terms at will and the other party has nothing to say about it?
Sure. Because the document also says that the employment handbook provides the terms and conditions related to the employment relationship between the two parties. And it sets forth that here's how we're going to work under this analysis. If the handbook's not an employment contract, then there are no policies and procedures that apply to the employment at all. That means that the overtime, the pay, the time off, the medical leave, things in there have no application whatsoever. That cannot...
Is it Rainguard's position that this document requires the employee to arbitrate disputes, but it doesn't require the employer to arbitrate disputes? It's a one-way obligation.
Absolutely not. The separate agreement, the arbitration agreement in itself references at least 2 times that this arbitration agreement. Rainguard Brands' position is that that applies to both parties. It binds Rainguard as well as the employees who sign off an acknowledgement saying that they've read and agreed to be bound by that.
But Rainguard can change that at any time. Rainguard can decide that it's not going to be bound by the arbitration language.
I don't think that's true. I think Rainguard could say there's no arbitration agreement related to the policy. I don't think Rainguard Brands can say we're going to change it to be a one-way arbitration agreement, that it only applies to the employee and not to Rainguard itself.
But in the acknowledgement, it says, I understand that except for my at-will employment status, any and all policies or practices of Rainguard can be changed at any time by the company.
It does say
It
that.
doesn't even say that that wouldn't be retroactive.
Correct. It does not say that.
And the reason I mention that is that, well, a couple of thoughts or questions. Like, first of all, have you found any case, a single case, where the separability doctrine has been specifically discussed in the context of an employment agreement?
I was not able to find one that talks in those type of language. I believe that some of the Ninth Circuit cases, Zoller, Renteria, I believe Nelson, and
But those don't involve the separability doctrine, do they?
I thought they made some comment to the effect of we treat these as the separability. It's a separate document from that. I think, but Circuit City Stores also does the same kind of thing versus Adams, where they applied and said that this does apply to employment contracts, the Federal Arbitration Act. And I believe that case talks in terms of we look at that as being a separate document from the document itself based on.
But can you cite me any law that says that we, in a case like this, that we're in determining the existence of a contract, whether there is an agreement that even exists, that the separability doctrine would separate that out first, or isn't that a threshold issue that we determine first before we even look at the separability doctrine? I mean, do you have a case that
Sure.
you can?
Sure. And I'm just trying to understand the question. My understanding of separability is that you look at the context that's presented here, and you have to determine, is the arbitration agreement as a separate document, is that a binding document?
But you're assuming that, to follow up on Judge Kiley's questions, you're assuming that there's an agreement. And aren't we at step one? Is there an agreement?
I believe so, yeah, that there is an agreement. And I think that's what both Prima Paint and Buckeye Cashing talk in terms of, is that you look at the arbitration agreement itself to determine, is that a contract? And if you read the terms of the arbitration agreement here, it very specifically says it applies to both sides. It uses the phrase, this arbitration agreement.
And I can understand that if you just look at that one page called the arbitration policy, if you just look at that one page. But do you not have to look at the acknowledgement also?
You have to look at the acknowledgement because that's what, well, let me back up. There has to be a written arbitration agreement. It doesn't have to be signed under either federal or state law. And I think you do need to look at the acknowledgement because it talks in terms of, I've read these and I agree to be bound by these policies and procedures. That's what separates this from Kumetz and Nelson. Those two cases don't have the agree to be bound by this. And the analysis here, if you look at it as a separate document, looking at the acknowledgement and the binding arbitration clause, which was called out for in the table of contents, it very clearly is a contract. This arbitration agreement, it's one page, it's the same font, it's the page immediately before the employer acknowledgement that Mr. Kaatz said that I agree, I need to read it, I understand it's there, and I agree to be bound by it related to my relationship with Rainguard Brands.
Okay. Page 46 of the handbook, the binding arbitration page, begins with, the company has adopted a policy that requires binding arbitration of any and all disputes. But page 6 says, the company can add, change, or delete any policies it deems appropriate without the consent or agreement of any employee. So the effect of this is that the company is saying the employee must arbitrate disputes, and we may or may not arbitrate disputes depending on whatever we deem appropriate. Right?
If it were to occur before a dispute arose, they might be able to change that. I don't think if the policy can change that. If Mr. Kaatz had come and said, I want to arbitrate my dispute, I don't believe that this document permits Rainguard Brands to say, we're changing our policy, we're not agreeing to arbitrate that dispute with you.
What in the policy prevents Rainguard from doing that?
I think the binding arbitration clause in itself says this arbitration agreement, meaning that it's a binding document in and of itself under the separability document that requires Rainguard to abide by the policy it presented and under which a claim is being made.
In looking at some of the case law here, it seems like the California Supreme Court, the Texas Supreme Court have weighed in fairly recently on similar issues, but and they actually upheld the arbitration agreement as part of an employment manual. But a couple of the key differences there were that there was an advance notice clause. In other words, if we're going to change, we reserve the right to change the policy, but if we're going to do that, we're going to give you 30 days advance notice or 6 months notice, so to allow the employee to make, I guess, leave the company if they want. And it can't be retroactive is another key component that they emphasize. It could never be retroactive. It could never affect the individual who's trying to have the agreement arbitrated, or if there's a dispute pending, it could never be retroactively the rug pulled out from under them. But we don't have those conditions here, do we?
We do not. There's not a retroactivity provision in here to that extent.
Notice provision. There's no notice provision, correct?
It says at any point in time that could happen, yeah, which might mean would be that without notice it could be changed. I do think, though, that the context of if they're going to change it, they obviously have to let the employees know that it's been changed. And the other aspect, too, is that if it hasn't been provided to people, it's not going to be applicable because nobody would have notice of it. I mean, they have to have some indication that there's a different policy that applies to them. I don't think Rainguard could say, you did something, we're changing our policy, and you're going to, to your detriment, and do something to you because you did something that the policy at the time said was okay, but now we change it to say that it's not. I don't think this document would allow for that. I do think that it's a prospective only. If we change a policy, it's only going to apply prospectively.
Can you cite to any provision in this document that limits the employer's ability to change the rules in any way?
I don't think the binding arbitration agreement in itself would allow that because it's a separate document, but I don't think there is anything else in there that says that. I think throughout the document it mentions for the fact that we can change policies at any point in time if we need to. I think that trying to be nimble, that if some situation changes, there are legal changes from the various states that Rainguard operates in, it needs to be able to say, hey, we have a new mandate from, the state of California, state of Arizona that we need to do. We need to change our policy right now, and we're going to go ahead and do that. Rainguard, but the other important thing here with this binding arbitration clause is that it is the very clause that was present in the document that Mr. Kaatz signed. There's no argument that somehow this arbitration agreement is different from the one that Mr. Kaatz agreed that he read, understood, and agreed to be bound by. That's part of this here. Are there other questions the court might have before I get into some of my other prepared remarks?
Just
Absolutely.
Comment. I don't mean to beat a dead horse, but at least I'm struggling with seeing the employment contract or the employee handbook as a contract because of one of the cases you cite is Shattuck.
Correct.
And the principle in Shattuck says an agreement which permits one party to withdraw at his pleasure is void and unenforceable for lack of mutuality. And so I guess that's, at least from my perspective, struggling with if one party can unilaterally change the terms of an agreement, how do we have a contract? That's what I'm struggling. And you've heard multiple questions
Absolutely.
along those lines, so I'm not trying to beat a dead horse. But
Sure. And I think
I'm struggling a little bit.
Sure. If you look at the Shattuck case, as well as the Shade case versus Dietrich that we cited, those very clearly say that they recognize there are situations like this. And they state that the way you analyze that from a legal standpoint is, does the party who cannot change that, did they ever have an opportunity to be able to enforce the agreement at any point in time, regardless of how short? And if that is the case, then it can be a binding contract. That was part of the issue in Shade. Here's the same thing here also, is that Mr. Kaatz always had the ability to enforce his binding arbitration agreement and to say, the policies in here about my leave, my vacation, my health benefits, my things of that nature, he had a right to enforce that during the entire time he was employed by Rainguard Brands. So I think that's where that it gets to that He did have the right to enforce it, so it does have some contractual issue here.
If he had tried
sorry.
to enforce it, the company could have said, we've decided to change the rules, no arbitration, and the rules are changed, right? The document allows them to do that.
I would disagree with that. I don't think that it would allow them, if he brings a dispute up and says, I want to arbitrate it, I don't think the document would allow them to change it and say, we're changing the policy, it no longer applies, that we can apply that retroactively because to your detriment when it's something that you might have relied on in the future. I'd like to reserve some time if I could for rebuttal, unless you have any
Council,
questions. Absolutely.
down, will you just look at the citation for the Shade case?
Absolutely, Your Honor. Yeah, thank you.
Good morning, Your Honors. It is my distinct pleasure to represent the appellee, Dustin Kaatz, in this matter. Starting right off.
And your name, counsel, just.
Thank you, Your Honor. Chris Mason.
Thank you.
Defendant Rainguard is attempting to bind Mr. Kaatz to a contract that did not exist, which was not mutually binding on Rainguard. There are really 5 crucial facts that are undeniable in this case. 1, the handbook itself says it's not a contract. It's very clear about that principle. 2, the handbook expressly states that it is a guide and a reference tool, not a contractually binding agreement. 3, it states the company could change the handbook at any time at its leisure. There's no restriction on its ability to do so. 4, the handbook acknowledgement echoes the indication that the policies and procedures can be changed by the company. And 5, the handbook acknowledgement makes absolutely no mention of an arbitration provision or an arbitration agreement. Under these circumstances, we submit that the arbitration provision at issue is not binding on either party.
But there is an additional fact. The acknowledgement says the employee was given the handbook, and he says, I agree to be bound by the company policies, and he signed it. So why isn't he stuck with that?
Well, in many respects, one of the biggest issues is the fact that that very same document, granted at a different place, says this is not a contract. I can agree to follow certain procedures. I can agree to pursue a certain course of action without creating a contractual obligation, particularly when it's a unilateral obligation. The Rainguard was not bound by this agreement.
They agreed to pay all the arbitrator fees.
Only if an arbitration goes forward. They have the unilateral ability to cancel it, though.
Anybody ever tested this arbitration agreement?
Not as far as I'm aware, no, absolutely not.
How would we presume that it's invalid if it's never been tested? And wouldn't, if your client tried to invoke arbitration and the rug really was pulled out from under him, wouldn't that be a classic case of breach of the implied covenant of good faith and fair dealing?
Only if there's
cases that allude to that case out there saying, hey, there is a remedy that the employee has that would, if it was a contract and they believed it was a contract, then they can't just unilaterally withdraw the terms.
I respectfully submit that if it's not a contract in the first place, the covenant of good faith and fair dealing doesn't apply. It only applies to contracts. So if we determine as the threshold question that the parties have not entered a contract, that covenant doesn't come into play. And I submit that it's not because it expressly says it's not a contract. The acknowledgement also gives them the unilateral right to withdraw. And this concept is addressed in detail in the Shattuck case that Your Honor cited to opposing counsel earlier. And there, the court expressly said a contract must have mutuality of obligation, and an agreement which permits one party to withdraw at its pleasure is void. That was the Arizona Supreme Court. It's still good law. It was cited recently even in a District of Arizona case for the very principle it stands for. When one party can withdraw, one party can say, we're not going to follow this, we don't have a contract. And I respectfully disagree with opposing counsel's interpretation of Shattuck. Shattuck doesn't go into detail about length of time you can enforce an agreement, if you have a 30-day notice provision. It does cite a Connecticut case that makes reference to that, but that's part of a larger citation. The Shattuck court was not addressing that issue. The Shattuck court was very clearly saying, if this is not binding on both parties and one can just withdraw, we don't have a contract there. And that's the issue in many of the arguments that have been raised in many of the issues in this case, particularly when we talk about things like the separability doctrine, which opposing counsel has argued in front of this court, but which was not raised below.
And counsel, is there a reason why you did not respond to that argument at all in your answering brief?
We didn't directly address that argument, Your Honor. I don't disagree.
Is that being a little? You didn't address it, period, correct?
We didn't address it, Your Honor. That's correct.
So you understand under our principles of law, we can accept that we can treat that as a concession of error.
Well, at the same rate, Your Honor, we've argued there's no contract, and our position is the separability doctrine only applies if there is a contract.
I'm chastising you a little bit here.
I understand, Your Honor.
But because if you had added a few sentences to that effect, it would have, made more sense. I think because when one party raises an issue and then the other party doesn't address it, then it makes you wonder what their position is. So I appreciate the candor. So speaking of these, I'd like to go back to the separability doctrine and explain, if you will, why it doesn't. I mean, what is the problem with that argument? Because there is a lot of language out there on this doctrine, and it's adopted it. And so help me understand and clarify why you think it doesn't apply here.
Absolutely, Your Honor. My understanding of separability talks about separating out certain contractual obligations, right? One part of an agreement is separable from another, so if one party breaches Part A, it doesn't necessarily excuse the other party from having to comply with Part B. That is my understanding, but it presupposes both parts are a contract. If it's not a contract, the separability doctrine doesn't come into play. In every one of the cases cited by opposing counsel on the separability doctrine, they had a contract. It was very clear they had a contract. In one case, they tried to argue there was fraud in the inducement, so it shouldn't bind them. And in another case, there was an issue about illegality, whether it was an enforceable contract, but there was a contract. And that's different here. This is not a contract. It expressly says that this handbook is not a contract.
I'm going to ask you the same question.
Sure.
Opposing counsel, were you able to find any case where the separability doctrine was applied specifically in the context of an employee manual to say, oh, we're just going to look at this page, 47 only of the contract? Have you found anything like that?
I have not, Your Honor. I haven't found anything that remotely resembles that. Speaking then to Leichfold, and I do think this is an important case. Shattuck was a very important case. Leichfold also an Arizona Supreme Court case, because we're dealing with essentially a Leichfold issue. And opposing counsel has cited certain language that suggests an employer can create a contractually binding obligation through an employee handbook. But the word is can. That doesn't read the full discussion of the Supreme Court, because the Supreme Court goes on to say, and I quote, "We do not mean to imply that all personnel manuals will become part of employment contracts. Employers are certainly free to issue a personnel manual that clearly and conspicuously tells their employees that the manual is not part of the employment contract." I've been a practitioner in this community for 25 years, and I draft employment handbooks. I'm an employment attorney. We called those Leichfold disclaimers based on the Leichfold case. They have a Leichfold disclaimer in their handbook. They're essentially telling us this is not a contract. And it comes right out of the principle articulated by the Arizona Supreme Court in Leichfold.
Page 46 of the handbook, the binding arbitration page, it begins by saying the company's adopted a policy requiring binding arbitration, but as Mr. Sanowski pointed out, the term arbitration agreement does appear twice on this page. So does that use of the word agreement there, does that establish that page 46 is a standalone agreement requiring arbitration?
I don't agree with that proposition, and I don't agree with that proposition because the overarching document that it falls within expressly says we can change this at any time. It is not a contract. We use the term agreement oftentimes very loosely. We may agree to do certain things. It doesn't necessarily mean we've entered into a contractual relationship. Using that term alone does not mean necessarily the parties have a contract. They can have an understanding and refer to it as an agreement. Additionally, counsel has argued that the arbitrator gets to decide whether or not the parties have an agreement. That's just incorrect. The courts decide that issue. In Arizona, Duncan versus Public Storage makes it clear, quote, in the Superior Court, a party seeking to compel arbitration must demonstrate the existence of an arbitration agreement. The Arizona Arbitration Act, and I know we're proceeding under the Federal Arbitration Act, but the Arizona Arbitration Act expressly states, quote, the court shall decide whether an agreement to arbitrate exists or a controversy is subject to an agreement to arbitrate. And that echoes federal law. It's very clear the court gets to decide the threshold question. When a party brings a suit and the other moves to compel arbitration, it's the court that ultimately makes the decision whether or not to proceed with arbitration.
Counsel, I'd like to turn you back a little bit to what was argued in the Superior Court somewhat strenuously, is the knowing waiver doctrine based upon the, I don't know if I'm saying it, Kaatz and Nelson cases from the Ninth Circuit. I mean, to cut to the chase, why rely on those cases when there's appears to be fairly obvious authority saying that those cases are limited to Title VII discrimination claims, and in that context, there needs to be a knowing waiver?
Well, I think there are really two principles at play. I'm sorry.
Are you suggesting that we affirm on knowing waiver or the lack of a mutual assent?
It's lack.
I guess maybe that's a better way to phrase it.
It's and I think it's the two doctrines are confusing, and I think that's part of the issue. It's an assent question. Did the parties assent to a contract? That's what's at issue in this case. The Kaatz and Nelson cases were cited because, quite frankly, they directly address exactly what we're looking at here. Did the parties have an agreement based on what's in the employment handbook without acknowledgement or without reference in the acknowledgement to the arbitration policy? And in those cases, yes, the courts did address the fact that they're Title VII claims, but nothing in those decisions, Kaatz or Nelson, says the reasoning doesn't apply in other contexts. Later Ninth Circuit cases do really focus on knowing waiver and the interpretation of the knowing waiver doctrine. But none of those cases say the same arguments and the same principles don't apply to other employment agreements that have, or employment handbooks that have an arbitration provision buried in the handbook that's not referenced in the acknowledgement. So that's why we were pointing those cases out. Yes, I do agree Ninth Circuit interpretation went a certain way, but there's not a single Ninth Circuit case, and I look for it, that says this argument, this principle doesn't apply outside. Mutual assent, correct, yes, under the circumstances where, the handbook can be changed. Additionally, I did want to point out that opposing counsel had cited to Harrington and the Rokes case for the proposition that if a party doesn't read an agreement, they're still potentially bound by it or should be bound by it. But again, that presupposes there's an agreement. And in both of those cases, there were agreements that were signed, and there were clearly contracts. The party just simply didn't read the arbitration clause. In one, Harrington in particular, although the party claimed they didn't read the arbitration clause, they literally initialed the page it was on. Those are very distinguishable cases, and they're very unlike the case we have at bar. So at the end of the day, we have an agreement that can be changed at any time by the employer. It can even face a situation where it feels an employee has breached a duty of loyalty, for instance, walked away with trade secrets, you name it, and may say, we're not going to arbitrate, we're canceling our arbitration policy, and we're going to pursue you in Superior Court. They have a right to do that under that agreement. Whereas my client, if this is a binding agreement, my client has no choice. He has to go to arbitration. This is not, there's no mutuality here. This is a void agreement as recognized by Shattuck. Are there any further questions I can answer for your honors? Thank you very much for your time.
Thank you. Judge Williams, I believe I misspoke when I was talking about the Shade case. It was actually the Shattuck case that talks in terms of states that quotes a Connecticut case that states where bilateral agreement contains a reservation to cancel at will by one party, the test is whether the party not having the option to cancel could at any time, no matter for how short a time, enforce the contract. The Shattuck case also, for its position about a contract that allows one party unilaterally cancel, that also, quote, it cites a different case. But it's important to know from the Shattuck case that they actually found a contract to exist in that situation and reversed and remanded back for additional consideration by the trial court. The Shade case that I had discussed is more of a mutual assent case. The citation for that, 158 Ariz 1 760 P. 2nd 1050.
Thank you.
Briefly, here there was mutual assent by the writings that were exchanged in the handbook and binding arbitration agreement that Mr. Kaatz signed off, stating that he read, understood, and agreed to be bound by. It's additionally shown that there's mutual assent by the performance of both parties, because after Mr. Kaatz signed off on that employee handbook, the parties began performing their employment relationship. Mr. Kaatz began working for Rainguard Brands. Rainguard Brands began having him do employment work, and the parties moved forward based on the policies, procedures, and conditions and terms set forth in that employment handbook. They believed they had a relationship governed by that employee handbook. That's the mutual assent one's looking for related to the entire context. The separability issue is also there because that binding arbitration agreement has to be something. But the other part of what the court does when it looks at written agreements, it tries to harmonize them to give effect to the parties' writings. What Mr. Kaatz and his counsel want here is they want a situation where this court gives no credence and no meaning whatsoever to a 47-page employment handbook that obviously the parties intended to have some meaning and some control and application to their relationship between each other. That would include how they get paid, time off, various things about your employment duties, what you can and can't do at work, what you can and can't do with work equipment, as well as a binding arbitration clause that specifically set forward and is indeed the last page before Mr. Kaatz signs an acknowledgement saying, I've read this, I understand it, and I agree to be bound by it, including that arbitration clause.
You speak of mutual assent.
Correct.
But the page 6 of the handbook, when it talks about the company can add, change, delete any policies it deems appropriate, it specifically says without the consent or agreement of the employee. So they're not saying we both agree to this. The company is saying we can change our policies anytime we like without your agreement, and it doesn't matter what you think, right?
Well, I think that the issue in that context, it does say that, but it's the parties agreeing that if there's a need for a policy to change, Rainguard Brands has the unilateral ability to do that. But Mr. Kaatz is agreeing to give Rainguard Brands that ability to change that if there's a need for that to happen.
So he's agreeing that they can change the policies to some policy that he doesn't even know about right now.
Yeah.
You can do whatever you want in the future, and I'll agree to it. And that's a valid agreement, even though you have no idea what it is you're signing up for?
Well, but he has the option, too. If there is a change to a policy he doesn't like, it's an at-will contract. He can terminate his employment relationship and not continue working for the company.
So that's the employee's remedy, quit. If you don't like it, quit.
I don't know what else there would be. I mean, in a situation where there's an employment relationship, it's going to have to be the employer who gets to potentially govern and strike that. If there's an employment at will relationship, it has to be that the employer has the ability to determine how they run their business and what policy procedures apply. The employee in this situation, Mr. Kaatz has agreed that yes, if there's a need for a policy to change, I'm allowing Rainguard Brands to do that. But it's also important here, Your Honor, to understand that Mr. Kaatz is not arguing that any policy change to his detriment in the employment handbook that he agreed that he read would bind him and that he was required to follow. All Rainguard Brands is doing is saying what you signed and said applied, that does apply, and it requires arbitration in this case. There's no argument that Rainguard Brands did what Your Honor is talking about and changed the policy and said, hey, guess what, we're springing a surprise on you. You need to comply with, and we're trying to apply something that you never knew about. Mr. Kaatz clearly knew about the information in this. clearly knew he was signing off on an arbitration agreement. The arbitration agreement itself on the page, very short, 9 paragraphs, same font, references this arbitration agreement. Under the separability doctrine, it applies in both federal and state court. As federal substantive law, it's a binding arbitration agreement. I have a few seconds if anybody has a quick question, otherwise I've completed my remarks. Thank you.
Council, we thank you both for your arguments this morning. This matter is under advisement, and we will issue our decision in due course. The court stands in recess to set up for our next argument.